introduction. I was saying something about the organizing association with the labor law community. It's an association of Italian and foreign scholars and practitioners of labor law, which was created something like 1 year ago, and with the aim, I was saying, to engage ourselves in a multidisciplinary debate and in comparison with other legal cultures and experiences, and as we feel to be part of a global community of lawyers. It's really a privilege to introduce this seminar on the USMCA, the agreement between the United States, Mexico, and Canada that has replaced NAFTA and the side agreement on labor. Let me start by thanking our distinguished keynote speakers for joining us in this event. Janice, Bellace, who is Professor of Legal Studies and Business Ethics at the University of Pennsylvania, and she's also President of the International Society for Labor and Social Security Law. And Lance Compa, who is Professor of Labor Law and International Labor Rights at Cornell University, and previously Director of Labor Law Research at the NAFTA Commission for Labor Cooperation. I also warmly welcome Giuseppe Casale, Secretary of the International Society for Labor and Social Security Law, along with the other speaker of this seminar, Professor Manfred Weiss of the Goethe University of Frankfurt, Professor Fausta Guarriello of the University of Chieti, Pescara, Professor Vania, Brino, and Valentina Cagnin of the Foscari University of Venice. And finally, we are very grateful to Tiziano Treo, President of the National Council for Economics and Labor and Honorary President of the International Society for Labor and Social Security Law, for accepting to conclude the seminar. Now, the focus of the seminar is this agreement, the new trade agreement between the United States, Mexico, and Canada, due to replace the North American Free Trade Agreement and the side agreement on labor. But I hope that our meeting will also offer an opportunity to reflect on what has been considered a period of backdrop of the process of globalization, which in fact has been in a big strain over the past year, and not only because of the pandemic. Even before that, we had had the worst economic and financial downturn in recent times, which seems to push towards a reallocation of the production at the local and regional level, and to reshape the chains of value with the wide processes of reshoring of material trade. However, recent studies, for example, I'm referring to the Global Connectedness Index issued by a company, actually, the DHL company, seem to show that globalization is more lasting than its enemies could predict. For example, globalization is still on the way as far as trade is concerned, mainly trade of services, of course, but also trade of goods, if we think of medical equipment, protection devices, and of course, of the vaccine. Also in the information flow, the cross-border internet traffic, as we all know and experiencing right now, has doubled in last year, together with a huge growth in international e-commerce sales. All this has been described as 3 years in 3 months process. In sum, it seems that we are facing a resilience of the global supply chain, but mainly in terms of trade in services and a reassessment of the global chain itself. Of course, these are all problematic developments, not least because they have substituted personal for digital relationships. But we can also look at the vaccine as another epitome of globalization. We would not be saved without globalization. Global problem requires global solution. In Golden, an influential expert of globalization, hold that globalization will not reverse, but face change. That we are at an inflection point. We would never thought that economic discussion would move from its orthodox way of thinking of globalization. And yet today, this pandemic, he says, It's like a wake-up call that teaches us that globalization must be managed, it can be managed. There are still missing pieces, of course, such as the loss of solidarity towards developing countries. But on the other hand, there are serious attempts to move on the path of coordination, of a virtuous link between regulation of international trade and promotion of social rights. And today we will discuss one of these attempts, and we are looking forward to listening to our colleagues and friends. And so I give the floor to Adalberto Perulli, who will introduce and coordinate the seminar, and whom I wish to warmly thank for organizing it. Adalberto, the floor is to you.
Thank you, Marzia. Good afternoon. It's a real pleasure to open this event about such a topical matter. Just think that today there was supposed to be a similar webinar organized by the Cornell University, and the Cornell colleagues were so kind to move the event to the next week to avoid an overlap. So I invite you all to attend this webinar entitled How Do We Fix Trade Policy to Help Workers, which will take place on Thursday, 19th January from 9 a.m. Well, time to focus on our webinar. And first of all, I would like to, of course, to thank the guests of this event very, very much for accepting our invitation, in particular, Janice, Bellace, and Lance Compa, who are our keynote speakers. And even if they need no introduction, let me just say that Janice Bellace is an international scholar, of course, with a rich academic experience. Just for example, Janice was the founding president of Singapore Management University, and as a specialist in international employment law, Janice was a member of the oldest UN supervisory body, the Committee of Experts at the International Labour Organization in Geneva. Lance Compa is one of the most authoritative world scholars in the field of international trade and labor rights. His academic competence is well known also in Europe. And I remember, just for example, that on these issues, Lance was the speaker at the World Congress of the International Society for Labor Law in Paris in 2006. But his expertise is also very important at institutional level. I just think that, as already Marzia said, Lance was director of labor law and economic research at the Nafta Labor Secretary. Both of them have been appointed by the US government as members of the panel under the new Usmca. And it's really a great pleasure to have this opportunity to hear their views on the new treaty. But let me point out some introductory notes, starting from the recent evolution of economic globalization and its social effects. Much has been said about the negative effects of economic globalization on labor law systems. For a long period, free trade was the symbol of a neoliberal philosophy that did not consider the social dimension of trade at all. Social clauses, although present in the free trade agreements, on the one hand, create a linkage between free trade and social rights, but on the other, did not seem capable of governing the economic market process that underlies these international agreements. Therefore, we have seen the resurgence of nationalism and widespread demands for neo-protectionism in defense not only of the competitiveness of the market, but also for in defense of local labor markets and employment. It is a wind that blew in America during Trump's mandate, of course, which has also involved Europe, where some countries, some EU member states are increasingly intolerant of the logic of market integration through common rules, pushing for autonomous solutions. One word, Brexit, sums up this situation. The new agreement we are talking about today is therefore an opportunity to review the process of economic globalization in the light of what institutional rationality can do to limit the negative social effects of trade liberalization. And I will try very quickly to indicate some points for this reflection. The first point, of course, concerning the new treaty, of course, the first point concerns the reference to the ILO labor standards. The Nafta labor side agreement had a basic weakness because it did not refer to the fundamental social rights established by the ILO. Now the perspective changes. The new labor chapter states that each party shall adopt and maintain in its statutes, regulations, and practices the right as defined in the ILO declarations on rights at work. And this reference is very important, but must be interpreted correctly. A footnote of the treaty reads as follows: the obligations set out in this article refer only to the ILO declaration. It's like saying that the norm does not refer to the rules that implement those principles, namely the related ILO conventions. And maybe in this way, the treaty seems to have missed the opportunity to reach most advanced models of social clause. I mean, for example, the model of the EU generalized system of preferences, which in fact requires trading partners to respect the 8 ILO core conventions. Of course, the treaty contains also a reference to the ILO Declaration on Fair Globalization. I believe that this reference is quite important in terms of values, because in that declaration, for the first time in its history, the ILO states that maintaining the competitive advantages of countries cannot be a valid reason for ignoring fundamental social rights. And this is an affirmation that breaks the traditional reliance that in international trade is placed in the comparative advantages of nations to the detriment, of course, of the social sphere. This is in particular in the WTO system, of course. There is another important progress which makes in this respect the new labor chapter maybe the most advanced model of a social clause in an agreement. It is about the rule contained in a footnote stating that the right to freedom of association cannot be realized without protecting the right to strike. And if we consider the internal dispute within the ILO on this point, we understand the importance of this statement. The second aspect that I would like to underline concerns the relationship between national sovereignty and supranational, I would say, harmonization. This is a classic problem of social clauses and has had various declinations. Just think of the experience of the European Union, in which the social dimension has prevailed according to a process of harmonization of social rights. And on the contrary, think to the Nafta labor side agreement, which expressly stated that it did not want to establish a common minimum standards for domestic law, but only to indicate areas of common interest in which the parties assumed the obligation to respect their own labor law. Unlike the labor side agreement, the new treaty maybe creates the conditions for some regulatory harmonization between states. This at least as regards the core labor standards, but also to other regulatory provisions, for example, with reference to wages. I am referring to the labor value content requirement, according to which in the automotive sector, at least from 40 to 45% of the value must be made by workers earning at least $16 per hour. As a consequence, maybe an embryonic common minimum standard seems to have been achieved, a sort of transnational minimum wage that helps to reduce the wage dumping of Mexican companies. The third aspect that I would like sorry, the third aspect that I would like outline concern the link between trade and social rights as a condition for the activation of sanctions against the country that does not respect its obligations under the agreement. This strict conditionality was evident in the Nafta labor side agreement, which provided for the possibility of having sanctions only if the violation concerned certain rights and only if this violation was such as to affect trade. And we have seen how important this point was, for example, in the US-Guatemala case, in the context of the CAFTA agreement. In this new agreement, the condition in a manner affecting trade and investments is maintained, but a footnote explains that this clause covers a person or industry that produces services or goods traded between the parties. And the responsibility to demonstrate that the failure is affecting trade shifts from complainant to the respondent country. And this is a decisive advance that facilitates the filing of a complaint. The last point, but not least in importance, concerns the procedural aspect. I am referring to the new rules of the rapid response labor mechanism. And this mechanism creates and authorizes an independent panel to undertake labor inspections and allow for the imposition of sanctions if the panel finds that a firm has not done enough to correct an issue. Under this mechanism, against individual companies, it is another novelty. Under the common free trade agreements, labor violations can only be filed over governmental breaches of obligations. In this way, if I understand, if I well understand the meaning of the treaty, we achieve a procedural innovation so that to create a mechanism that can lead to the imposition of commercial sanctions directly against the firm. Before passing the floor to the speakers, I would like to stress the importance for labor law scholars to consider this agreement as a significant step in the long path that links trade, investments, and social rights. Globalization is a powerful vector of change in labor law systems because it has put social systems, businesses, and workers themselves in unprecedented competition. And thinking of reacting to these problems in a national logic is now meaningless. Given the current crisis of multilateralism, only large regional agreements such as the USMCA and maybe for the future other treaties on a global scale can be the right way to combine market, economic development, and social justice. And now, without further ado, I give the floor to Lance for the first keynote speech. Lance, the floor is yours.
Thank you, Adalberto, and thanks to you and your LLC colleagues who helped to organize this webinar. Adalberto anticipated many of the points that I included in my prepared remarks, so I'm going to try to move more quickly so that we'll have more time to hear from Janice, Bellace, and Manfred Weiss and our other colleagues. As Adalberto pointed out, the USMCA defined new obligations of the parties compared with the Nafta labor agreement. The Nafta labor agreement only obligated parties to effectively enforce their national labor legislation and conceded that countries have full sovereignty in determining their national labor legislation. It would not be determined by reference to international standards such as ILO conventions. The new agreement requires parties to adopt and maintain in law and practice. And this inclusion of the practice clause is important because, as we all know, laws can be written to be very beautiful, but what happens in practice is really what matters. So practice is incorporated into this obligation, and the parties must adopt and maintain in law and practice national legislation that is consistent with the ILO declaration, the 4 elements of the ILO declaration. As Adalberto pointed out, there's a footnote that says this only refers to the broad principles of the declaration and not to the 8 ILO conventions that are associated with the 4 principles. The United States insisted on this distinction because, as I'm sure you all know, the United States has ratified only 2 of the 8 core conventions. I think it will be interesting if a case ever reaches a point of arbitration on this point as to whether in law and practice a country is acting consistent with the declaration. How will an arbitration panel decide this question without referring to the conventions? Because only the conventions give concrete meaning to the broad statements of the principles. So I think this is it's a case, waiting to happen. And I think that this will really put to the test whether the United States can successfully exclude the conventions from being considered. The second obligation, in addition to the adopt and maintain obligation, is the obligation to not fail to effectively enforce national labor laws. This question of effective enforcement is still central to this agreement, just as it was under the Nafta labor agreement. To enforce national labor laws, both on the ILO core standards and on what is called acceptable conditions with respect to wages, hours of work, and occupational safety and health. However, acceptable is not defined in the agreement. It does not indicate whether acceptable conditions relates to ILO conventions on these subjects. So again, a case that arises on a question of wages, hours of work, and occupational safety and health will have to be decided by reference to some standard by an arbitral panel. And so the question remains acceptable to whom and using what standard. As Adalberto noted, there are really two dispute resolution mechanisms contained in this agreement. One is the traditional government-to-government dispute resolution system, which has effectively three stages. First, a soft stage of government-to-government dialogue, then a more formal stage of government-to-government consultation. But then, if there's not a resolution of the dispute, arbitration by an independent arbitral panel, which can impose trade sanctions if a country has failed to enforce its labor laws in a manner affecting trade. Adalberto signaled the importance of this phrase and the way that it was handled in the Guatemala case, where the arbitral panel found that Guatemala indeed failed to effectively enforce its labor legislation in a traded sector, in a sector that involved trade among the trading partners. But the arbitral panel said that the United States failed to show that the companies who committed the violations changed the prices of their goods to gain a competitive advantage. Of course, they could still benefit by having lower labor costs by their violations of workers' trade union rights. And the clarification in the new USMCA is meant to cure this problem, to remedy this problem. And again, we'll have to see in a specific case whether it has effectively accomplished this. The other enforcement mechanism is this novel rapid response mechanism, which allows complaints against a company for violating workers' trade union rights, not just against a government for failure to effectively enforce its national labor law. The rapid response complaint requires only a good faith belief that workers at a particular workplace were denied their trade union rights of organization, collective bargaining, and the right to strike. And there's no requirement to exhaust domestic labor procedures. This rapid response mechanism can be invoked immediately when there is a good faith belief that violations have taken place. It also provides for a rapid timeline. There are 45 days for the parties to resolve a dispute amicably. But after that, there can be the formation of a 3-member rapid response panel that is supposed to decide within 60 days whether a violation took place, whether it is unremedied, and that in that case, trade sanctions can be imposed against the company, the particular employer where the violations took place. One important point that we need to keep in mind is that a rapid response complaint has to be initiated by a government. Private sector organizations, such as trade unions or NGOs, have to request their government to file a complaint under the rapid response system. So the question of a government's willingness and desire to enforce this clause still depends on the government making a decision. The unions can only try to persuade their government to initiate a case. The unions cannot initiate a case on their own. When the agreement first went into effect, there was some discussion that unions would quickly file a case under this rapid response mechanism, but they have not. There has been some discussion in the trade union movement and with the U.S. trade representative about whether a case could be brought involving violations that happened before the new agreement went into effect, but where the results of the violations are still being felt. That is, workers have been dismissed for their trade union activity. A corrupt union is still in place because of violations of trade union rights. And the US government is telling the unions that they would rather have a case involving events that take place after the agreement went into effect. And this is still being considered and discussed between the trade unions and the government. And of course, it's a Trump administration US trade representative that is dealing with this. Next week, it will be a Biden administration US trade representative. So we'll see if there is any further development along those lines. The agreement also, well, as a result of the agreement, in the context of the negotiations and the agreement, Mexico undertook significant reforms in its own labor legislation. I think this is an important point, and it shows the power that can be generated by the process of trade negotiations to bring about change in domestic legislation. Of course, the Mexicans did it through their own constitutional and legislative processes, and it's a result. It's not the trade negotiations were, let's say, a triggering event for the labor law reforms in Mexico, but actually the independent trade union movement in Mexico has been working for many years to push for these reforms. So they took advantage of the trade negotiations to accomplish their goals and set up labor law reforms that should effectively abolish the corrupt what's called protection union system in Mexico, the sindacati di protezione, where employers choose the unions that they will have, so that these corrupt unions will protect the employer against having a genuine union. Let me just close with some thoughts about the implications of this, the USMCA for European Union and United States negotiations on a future trade agreement. The USMCA raises many questions about how the EU and the United States would approach these issues in any negotiations. For example, the EU has required its trading partners to ratify all 8 of the ILO core conventions. And in fact, Canada and Mexico went on to ratify certain conventions, core conventions that they had not previously ratified because of the negotiations with the European Union for a trade agreement. Will the European Union insist as a condition of any trade agreement that the United States ratify the 6 core ILO conventions that it has not yet ratified? We don't know. It will be an interesting challenge and an interesting question. The United States, for its part, insists on enforcing labor chapters in trade agreements by arbitration and economic sanctions. And until just recently, the European Union relied on consultation with other governments to address problems, not hard sanctions. But if I understand it correctly, the new European Union UK agreement does provide for dispute resolution and arbitration with potential sanctions as a remedy. In what direction will US-EU negotiations go on this point? Will it go in the direction of soft law diplomacy and consultation, or in the direction of hard law economic sanctions? These are just examples of many complications that will arise in EU-US trade negotiations. But I stop here because I'm eager to hear the presentations of Janice, Bellace, and our other colleagues in this webinar. Thank you again for the opportunity to join you today.
Thank you, Lance. Firstly, before I start, I would like to thank Adalberto and the organizers of this webinar on behalf of the International Society for Labor Law, because it's a wonderful example of the purpose of the International Society to bring people together, to exchange information, to learn what's happening in other countries, and to discuss the implications. So I looked at the list of people who are participating, and they're, although many are Italians, of course, we have people from many other countries. And so I thank you once again for this on behalf of the Society. Now, going to Lance's point, I'll be a little bit broader than just the USMCA to give some context for this. The original NAFTA was drafted back in 1992. This is before the ILO declaration. And it was, most of the negotiations occurred during a Republican administration in the United States. So in one way, NAFTA should be seen as a great breakthrough because it was the first time that there was consideration that there should be a link between trade and labor. And of course, trade and labor rights in a trade agreement. And of course, that became the big controversy, if I can say so, throughout the 1990s. Many of you will remember the first ministerial meeting of the World Trade Organization in 1998, where there was an attempt to link labor rights and trade. We know that once the ILO declaration was adopted in 1998, that the 4 fundamental principles in that declaration were seized upon, I use that word like grabbed, by those who draft free trade agreements and inserted into free trade agreements, as if to say everybody agrees on these 4 principles, and so we can insert them. And there's no more, we don't have to have any big debate. Once again, that's an advance, but it raised many issues, as have been mentioned. If you say that you have a principle in the labor chapter that the parties have agreed upon, do you mean that there's simply support for some general principle, but nothing specific? Do you mean that whatever the word you use, let's say child labor, do you mean that it's what's defined in national law and practice? Or are we referring to something in international law? And as Lance has mentioned, if we're referring to something in international law, do you mean an ILO convention? For the United States, until now, it did not mean an ILO convention. And in fact, it specifically delinked, cut off the link between the principles and the 8 core conventions. You had to read the footnotes. It was written in an interesting way, but it basically said, when we say the ILO declaration, we are referring only to the declaration. The implication was we are not referring to the conventions. In the USMCA, it's more vague. That's the only thing I will say. It doesn't specifically de-link, cut off the link, but it doesn't link it either. So that's we're in this very vague situation. Most of the people that are participating today, I think I looked at, are lawyers, and so I will try to be a bit more specific here. I see Desiree Leclerc is on the session, and next week at Cornell, I think they're going to be broader and speak more about social and economic means of advancing workers' rights, not just the legal side, but I will try to be on the legal side. I'll come back to the right to strike, but I would just like to use one that's important in trade, and it's child labor. If you say there should be no child labor, everyone says, oh, you're right. You all agree with the principle. But then you say, what exactly do you mean by child labor? Can a 15-year-old be working 30 hours a week in a factory? That's a specific question. And where do you look for the answer? Well, there is an answer, and it's in Convention 138 of the ILO. But the USMCA doesn't refer to that. And in fact, it says under the labor rights section that the parties agreed the effective abolition of child labor, and as we know, that's from the Declaration, and for the purposes of this agreement, a prohibition on the worst forms of child labor. For this agreement, we're willing to have the prohibition on the worst forms. Well, that's Convention 182. But to be frank, in most factories, we're not talking about the worst forms of child labor. We're talking about old-fashioned regular child labor, having like 14-year-olds working in the garment factory. So when you read the USMCA, you're not sure what that means. And we know that 14-year-olds usually will work for less money than an adult. So there would be a cost advantage by employing adolescents if permitted. So these are the issues where the language I consider very slippery indeed, that you don't know what it means. Now, on the issue of freedom of association, as Lance mentioned and as Adalberto mentioned, this has been very controversial and internationally also. All of you know that in 2012 at the International Labor Conference, the employers group took the position that the right to strike was not inherent, I put it, in Convention 87. This was a shock to many people, which I will not get into, but let's just say 50 years of cases before the Committee on Freedom of Association and also the Committee of Experts observations would have indicated it was. So that was a shock. And I know a couple of people on this call have been authors on the book, The Right to Strike and International Law, which looks at it from the viewpoint of international law, not national law. Well, in the United States, the notion of freedom of association is much more narrow than in the European Union. Which workers are protected by national legislation? It's a much smaller group than in EU countries, much smaller. So I think that's extremely important to realize that if you do not refer to international law in saying who has freedom of association, if you fall back on national law, there's an issue if the United States is one of the signatories to the trade agreement. And in fact, the USMCA, in saying freedom of association, as a footnote, footnote 6, which says, for greater certainty, the right to strike is linked to the right of freedom of association, which cannot be realized without protecting the right to strike. Now that's an advance on some positions that were taken in 2012, but still it doesn't say who has the right to strike in the first place and under international or national law. And then it says, well, I won't go on to that, but I would just say that this is one of the issues that Lance highlighted, and you really have to look at each of these 4 fundamental principles. So I will simply say, under freedom of association, the United States has not ratified Convention 87 or 98. 87, I would be the first to say, generally being the more important one here for the purposes we're speaking about. It's quite detailed. There's an excellent book written, monograph written in the 1980s by Edward Potter, which some of you may know, very long time representative of the employers at the ILO for the United States, very knowledgeable person. But he specifies all the issues under US law, and there are many. So we've not ratified either convention under freedom of association. Under forced labor, we have not ratified convention number 29. We've only ratified 105. The main stumbling block would probably be private prisons, but still it's troublesome that we have not ratified 29. Under non-discrimination, it surprises me that the United States has not ratified Convention 111 on non-discrimination in employment. At one point in the late 1990s, people thought we might when President Clinton was president. The United States employers in the U.S. Council on International Business were not opposed, but nothing happened. The interesting one is Convention number 100 on equal pay. The United States does not guarantee equal pay for work of equal value. And the United States has stated in the ILO that the reason it does not ratify Convention 100 is that reason. So it's a very, very different standard than what is being followed in Europe. And on child labor, as I mentioned, the United States has not ratified Convention 138, the one that would be applicable in most factory situations, which is where garments, footwear, all these things are made, in part because our national legislation is rather complex, has many exemptions, and state law plays in. And I would point out that the child labor rules do not apply to family-owned farms, which is an issue. It's been brought up in the United States. Let's say if you have farms where people are picking blueberries or something like that. It's a loophole in my opinion, but it's something we have not changed. So that when you look at these four fundamental principles that are in the USMCA, and then you think as a lawyer, how would I proceed? You see big issues that crop up. Beyond that, I would say that the enforcement mechanisms are very important. As mentioned, until recently, the European Union did not have enforcement mechanisms beyond consultation. If your trade agreement is with a partner that is somewhat similar to you and has somewhat similar standards, then consultation can take you a good way. So if it was just the United States and Canada, perhaps we would, find it easier. But as you trade with countries that are very different and at very different levels or understanding of standards, consultation you often will not get you very far. And that's why the enforcement mechanism is important. As Lance pointed out, up until USMCA, the enforcement mechanism was arbitration. And as turned out with the Guatemala case, it shows how difficult that was. Now, this could be made easier. I saw Lance's prepared remarks, and he mentioned the various stages that you have to go through to reach arbitration. I'll only say it took 9 years in the Guatemala case to even get a decision. Obviously, this is not as there's that saying, a remedy delayed is a remedy dispute resolution process. You would want it to move faster than that. But secondly, you should have arbitrators who are knowledgeable about labor rights, which is another thing that that the new USMCA specifies, and not regular trade arbitrators. And thirdly, who has the burden of proof becomes very important, and Lance alluded to that. But what happened under the old standard was that the complaining party had to show that the violation was in a manner affecting trade, which is actually very, very difficult to do, particularly if you have a violation that's over a number of years and that trade patterns between the two countries have changed and currency rates have changed. It's extremely difficult. So that the new USMCA, in a sense, reverses that burden and puts it on the respondent, not on the complaining party. It says if the complaining party shows there's been a violation of labor rights, it's presumed that this affects trade, and that the other side would have to rebut that. That is as we all know as lawyers, who has the burden of proof is extremely important, and that's something that someone drafting a free trade agreement should look at. In my view, the rapid response mechanism is perhaps one of the most important for two reasons. Obviously, speed. In the freedom of association case, if the union is trying to organize workers and workers are being fired, or in the case of Guatemala, shot, you need speed is of the essence. So that's important. But the second reason is really important. In these trade agreements, as you have one government that is essentially trying to pressure another government to change, to do something. And as Lance mentioned, firstly, it depends on the complaining party's government. And take the case of Guatemala, that case, as I said, it went over 9 years. We had a Democratic administrations and we had Republicans. It kept changing. So you don't always even have a consistent line of argument on the part of the complaining government, let alone the responding government. And there's all sorts of diplomatic reasons why one may or may not want to put pressure on your trade partner government. So to have a mechanism where you say, in this case, we will target the employer, the company. We won't say the whole government, the government of that country is failing to do something. We will just look at this one company. That becomes a more realistic enforcement option. And also that the sanction is that that one company gets delisted from trade privileges, not the whole country. So you can see why this idea of allowing a response mechanism that targets the offending or the allegedly offending employer becomes a very, very realistic and useful option versus the regular one that leads eventually to arbitration between one country accusing another country of failing to do something. And I think if the EU were to, well, it is in the process of negotiating an agreement with the United States, but a very slow process, I'd be the first to say. One should look at this because the United States is so diverse, and the way labor rights are observed in different states is so different that it could be quite useful to target the employer rather than the entire United States. And getting back to freedom of association, if in the USMCA, it says the parties affirm their obligations as members of the ILO, including those stated in the ILO declaration. One of the obligations is to support freedom of association. We know that in the past few years, a union has tried to organize workers at Volkswagen in the United States. I don't have the time to go into it, but I could only say that the governor of the state that was involved outright came out and was against this, and basically said that there would be negative repercussions if this occurred. Now you would say, isn't that a direct violation or undercutting of this thing about the parties affirming their obligations? So getting back to my earlier point about understanding what the other side, the other country means by these general principles is very important and is something that the EU would have to be aware of as they move forward. I do think as I said, the USMCA is a step forward and an important step forward. And with President Biden, we shall see what happens. Trade is important. It's nothing. I know we talk about globalization, but the Roman Empire had trade across other parts. It is something that's not going away. I also personally believe that we should not put too much weight on trade agreements to improve labor standards generally. But the commitment to the fundamental principles and putting some teeth into them, that they actually mean something, is important. And as we go forward, I hope that future trade agreements or revisions of existing ones will make progress. Let me stop here, I think, and so we have time for discussion afterwards.
Thank you very much, Janice, for clarifying, in particular for clarifying the problems arising from the failure to refer to the compliance with ILO conventions, which is serious because in the USA, USA has not ratified these conventions. But I wonder if the panel can use a purposive interpretation. I would say, interpreting the treaty in the light of the reference to the principles, in a way to give an interpretation of what is the reference to the internationally labor rights, recognized labor rights, which is the typical ambiguous reference we had also in the past. I don't know. It's just a question for you and Lance, because otherwise I don't understand well how the panel can operate and evaluate if a situation is against the so-called internationally recognized labor rights, if we don't have any reference to the conventions. I'm wondering how the panel can operate. Anyway, now we have the planned speeches. So let me introduce the next host, Manfred Weiss, of course, a medical, a former president of the International Industrial Relations Association, and of course, honorary member of the labor law community. Thank you so much, Manfred, for joining us, and the floor is yours.
Well, good evening. It's my pleasure to be with you, and I'm grateful for being invited, because in this horrible situation of being almost 1 year now under Corona restriction, I'm happy to see the friends, and to have an opportunity to discuss with you. Thank you very much. Well, much of what I wanted to say has been said by the former speakers already, so I can be very brief. I would like to look at this new agreement, if you want, from a European perspective. And I think if you want to be honest, we should not forget how this new agreement came about. As far as I read, the main motivation for this agreement was the government's impression that American companies did not profit enough from Nafta. So it has a sort of, if you want, protectionist perspective. And this should not be forgotten when we just look at the text and are happy about what's in the labor chapter. Of course, I do not want to ignore the improvements. As we already heard, Nafta was an agreement which tried to maintain the domestic legislations, the domestic law, and to prevent derogation for trade purposes. This now is different. We have not only the maintenance, not only the prohibition of derogation for trade purposes, but we have an attempt to adopt new standards. And there are quite a few standards, you know, which are a real improvement. I just remember or remind you that we have, for example, the lowering of the threshold to initiate a complaint. We have a facilitation of the procedure to investigate such complaints. We have what I think is very important, a rule which makes it impossible that you can block a panel if the other side is not willing to nominate experts and so on. Then we have, as we already heard, which also I agree with you, Janice, which is of utmost importance, the shift of the burden of proof. Excellent. We have this, what Adalberto told us, you know, the rapid response labor mechanism. And of course, only for very few situations. And we have a direct access, not only to the governments, but to the violating companies, you know, which also is an enormous, enormous improvement. So I could extend this list by far. There is no way but to say that this agreement compared to Nafta is an enormous progress. There's no doubt. The problem is that I can't help, but I always have in mind this protectionist pattern. Let me give you two examples which you mentioned. Of course, it's very nice that we now have, for the motor vehicle industry, a requirement for 45% of the content of these motor vehicles to be produced by workers with an hourly wage of at least $60. Fantastic, very good. The problem is only that if you look closely, this will be difficult for Mexico. It's easy for the United States, it's easy for Canada. So I'm asking myself, is the motivation to do this really to help the workers? Or is it not, again, a protectionist pattern? The same is true if I read about these very interesting reforms to be made in Mexico. Well, these reforms are okay and they are necessary, as we heard from Lenz when we told us about the yellow unions in Mexico. The problem is it only for the well-being of the workers, or is it again protectionist? I simply ask this. Maybe I'm wrong. I would be happy if I'm wrong. But let me now come to the main part, the part with the ILO. First of all, let's look at the Declaration on the Core Workers' Rights. To these principles of the four rights. The question, of course, is, and here I come to Lance, would this be enough for the European Union? My answer is simply no. If you remember the negotiations on TTIP, it was consensus among Europeans, in particular among the European trade unions, that there will be no agreement without ratifying these conventions. And we have it later on in CETA, as you know. And in CETA, they have it in there. And that's why Mexico has ratified what they didn't have ratified yet. This will remain, so the possibilities of a trade agreement between Europe, the European Union, and the United States, I don't see it. I don't see it as long as the United States are not willing to ratify the conventions. And then, of course, I have a big problem with this reference which says one should adopt and maintain, not only maintain, specific laws related to acceptable conditions of work. What are acceptable conditions? We have already talked about this. Nobody knows. What is the point of reference? Are these ILO conventions? Are these principles derived from ILO's conventions? And if you look at what they have there, it's hours of work, wages, and conditions of work, and occupational safety and health. Whatever that means, I don't know. I think it would have been better to relate it to ILO conventions, which apparently one didn't want. But there's another thing which would be problematic from a European point of view. Because one area is missing, and already in the TTIP negotiations, it was clear that the trade unions would not agree to an agreement without this. And I'm talking about job security. I'm talking about protection against unfair dismissals. In other words, for the Europeans, employment at will would be no pattern to be agreed. And therefore, you know, this is an area which we should think about. Because, first of all, there is an ILO Convention 158, which is ratified by the European states. And secondly, there is the European Charter of Fundamental Rights, where we have the Article 30, which makes the protection against unfair dismissals a fundamental European right. And I don't see how the Europeans would give up this position in a trade agreement. As far as arbitration is concerned, Lance, I think there is some move. I have read, it was not a nice job, I can tell you. I have read these 1,265 pages of the agreement between the UK and the EU. And you're right, there is arbitration now. But there's one thing which is basic, and this, of course, would be the precondition for arbitration, as I can see it from a European perspective. It has to be a body which, beyond doubts, is neutral and is professional. And as you can see already in the CETA agreement, where we have for the conflicts of investors and governments, no longer ISDS. Of course, I must say, in this agreement, ISDS was reduced enormously and now is only for very few things, you know, and it's no longer for the next 3 or 4 years, as far as I understand, between United States and Canada. It's only between United States and Mexico. Here we have a totally different pattern in CETA. This is a sort of quasi-tribunal, you know, which is acting there. Of course, in reality, it does arbitration, but it's a totally different body from, for example, an arbitration body like ISDS. In other words, there might be, if there will be a trade agreement, there might be something like a arbitration body, but it will need lots of negotiations for developing such a body. By the way, if you look in the agreement between the UK and the European Union on the Brexit, it's very funny because there are so many events and incidents where we will need arbitration that I don't see how this arbitration body they have created will ever be able to cope with all these tasks. In my view, it is totally unrealistic, but that's my personal view. Well, there's of course another problem with this agreement, with this United States, Mexican, Canadian agreement. And this has nothing to do with labor, but it doesn't resolve the problems which should be resolved when Europe should start to have a trade agreement, for example, with the United States. And this is the World Trade Organization. You know, the blocking of the World Trade Organization's appellate body still exists. It is not changed yet. And the agreement doesn't say anything to this. Let's hope that the new administration in the United States will rescue this, will heal this. We will see. Taking all this together, I was warned that I should be very brief. I leave it with this, and I simply would say the perspectives for a trade agreement between EU and United States are not very realistic yet. Reading this new agreement, which, I repeat, has enormous improvements compared to the Nafta agreement. Thank you.
Thank you very much, Manfred, for giving us a vision from Europe. Of course, your evaluation is positive compared to the Nafta, but at the same time, you say that there is some protectionism in this treaty. Of course,
you see it already. Sorry to interrupt you. You see it already when you read not only the labor part in that agreement, but when you look, what about the companies, in particular, the big, huge platform companies, electronic platform companies, they have now better conditions than they had before, you know, which of course only can be explained by this protectionist perspective, which has motivated the whole agreement. Sorry.
Yes, of course. I would say just that this evaluation can be said at the end for any free trade agreements. You know, it is the recurrent accusation against the social clause. So I agree with you, but
I'm ambiguous.
It is a point of view, is a very interesting point of view. Of course, I agree with you on the vagueness of the regulatory references, and for this reason, I was wondering if the panel, and I would like to ask to Lance and Janice, if the panel can interpret these references in the light of the ILO principles, and in this way reach the ILO conventions. This is the question I would like to
I agree.
To stress. I don't know if Janice or Lance want to say something about this problem. Anyway,
I will very quickly.
thank
Firstly, on the issue that Manfred first raised on protectionism, I think he's correct. And I would point out, it was not so much protectionism as a calculated political maneuver.
Okay, you can call it
one industry was singled out, and that was the auto industry.
Yeah.
Okay. And the auto industry is heavily located in certain states. I mean, the most of the workers are in certain states, including Michigan, which were incredibly important in the presidential election. So it was just the auto industry, not other industries such as garment making or people who make washing machines. So that's why I say I looked at it as cynical, frankly. However, from the viewpoint of being protectionist, and from the viewpoint, and I'm going to bring my Asian background into this, from 1998, from the viewpoint of certain countries saying, oh, you want certain things to protect your workers, not because of workers' rights, just to protect jobs for your workers, I would agree that that is protectionist and is to be deplored. Now, the thing about protecting or favoring companies generally in certain industries, which is beyond the scope of this webinar, I think, boy, that does happen all the time in trade negotiations. And rules of origin is another huge point of contention. And maybe someday in the future we might have a webinar about the one the United States refused to ratify the Trans-Pacific Trade Agreement, which is huge, which Canada and Mexico are also part of, and a very important one, but would even get into a bigger issue of how do you list ILO fundamental principles and in any meaningful way have them abided by in certain countries. But we will skip that.
Thank you, Janice. Now I give the floor to Vania Brino. Of course, Vania Brino is a professor of labor law and international labor law at Foscari University. Please, Vania, you have the floor.
Thank you, Adalberto, and good afternoon, everybody. Let me just say that in my brief speech, I would like to point out two main questions, such as the first one is related to the main critical issues linked to the global value chain. And the second one is a sort of idea to reflect on some provisions contained in the USMCA, which maybe could be useful to, or which could be considered a sort of positive evolution in the debate on global value chain and their regulatory gaps. So relating to the problems, as we know, the global value chain is located in several juridical systems and with different legislation. So it's a key factor in terms of normative dumping. But we know also that companies exploit this economic model to save and to reduce costs and to minimize their legal responsibility. We discuss of social dumping. Of course, these two critical factors have a strong impact in terms of exploitation of workers, in terms of bad labor conditions, in terms of poor access to remedy in case of violation. And also we can identify problems in terms of control for the companies, in terms of control to all the suppliers located in the global value chain. These kind of problems have been amplified in time of pandemic, of course, and also nowadays we can identify another problem, such as the too long global value chains and the excessive specialization on products considered essential for health and safety. So we can, just an example, we can observe multiple pressures forcing enterprises to reduce their dependence on Chinese sourcing in particular. Of course, this problematic scenario introduce, or we can say push a debate, a new debate in terms of possible regionalization of the global value chain. So I would like to say that this treaty, the USMCA, could be a sort of example in this perspective. Because finally, it's true that this agreement incentivizes a sort of relocation of supply chain. It's probably not so realistic that all the jobs located far outside North America will come back to the US, but I think that it's evident that this new treaty introduces a new way for companies to take into consideration the risk of long global value chain, and also, of course, consider the benefits of free trade under this new treaty. Let me move on the second part of my short speech, I try to identify some provisions which could be useful in this debate, such as in terms of solution, possible solution to reduce the regulatory gaps that are linked to global value chain. And I think, as Professor Perulli said before, that maybe one provision as Article 7 in Chapter 4 could be a good way to, or a sort of a good model to try to solve the social dumping and also the normative dumping. Of course, it's a norm related also only to the automotive sector, and it's a norm related only on wage, it's true. So maybe I'm so much positive taking into consideration this new rule, but I think that it could be useful to introduce a sort of common playing level of regulation in terms of salary. And maybe, and also some scholars stress this point, it could be also considered as a model for future labor chapters in trade agreements. Of course, we couldn't analyze ex ante the effect of this provision. It's really complex, the process to implement this kind of norm. But I think that this labor value content sets a sort of interesting precedent by naming of a concrete average wage level. And according to a global value chain perspective, I think that we can identify another provision in terms of monitoring system. It's the norms related to Chapter 5 of the treaty. It's interesting because the treaty contains important references concerning the monitoring system. And the USMCA requires companies to identify some data elements to claim preferential treatment. And according my point of view, it's an interesting point because it means that for companies, it's more and more important to know their partners, because in this way, they could also control and try to control the implementation of the new standards in all the production. Of course, this kind of provisions could introduce also some problems because it's not easy for companies not only to know, but also to control the enterprises and the contractors of the global value chain. But I think that as final remarks, and I'm finished, that this new treaty, how can I say, stress the attention for companies and for importance role to strategy in the identification of the suppliers. So I think also in terms of traceability, it's really a key element also due to the increasing role played by consumers. So I think that this, in the future, the real challenge for the enterprises could be also a sort of revision of the manufacturer and the supplier agreements, because it's fundamental to apply these new rules, also take into consideration the behavior of the contractors and subcontractors. So I finish. I know that it's too late, so.
Thank you. Thank you very much, Vania. Of course, you have reflected on the treaty in a in a logic of global chain value, and you have also evoked very important issues concerning the regionalization of globalization. Is a topic that even Tiziano Treu has recently dealt with in the National Council of Economy and Labor. So thank you very much. And now the floor is to Valentina Cagnin. Valentina is also a scholar from Foscari University.
Okay.
Thank you, Valentina.
Thank you. Good evening, everybody. Before starting, just let me thank Professor Perulli and Professor Barbera and the labor law community for organizing this webinar. It's an honor for me to share this floor with professors of such expertise. Today, I would like to explain you the novelties introduced by the USMCA with regards to ISDS, the Investor State Dispute Settlement mentioned by Professor Weiss. I would like to show you two opposite trends. The global trend away from ISDS on the one side, and on the other side, but at the same time, the risk of an increase of ISDS cases due to the COVID-19 pandemic. Before starting, let's see very briefly how the ISDS works. It is a mechanism of dispute resolution in free trade agreements and in many bilateral investment treaties, according to which corporations can sue governments in international tribunals for lost profits, which may result from policy changes, and ask for compensations of damages. ISDS cases passed 1,000 mark, and Nafta was one of the most famous free trade agreements with ISDS, and one of the most used, because since 1992 we had 70 cases under Nafta Chapter 11. And now the USMCA still provides the ISDS, but the new ISDS is very weaker. The ISDS in the USMCAs has several significant differences from the NAFTA ISDS regime. And first of all, Canada is out from ISDS. This means that under the USMCA, the investor states arbitration is limited to the United States and to Mexico, as Professor Weiss already explained us. Well, the main reason of this exit is that Canada is one of the most frequent respondent states in the world with the 29 ISDS cases. And all the 29 cases were filled thanks to the NAFTA ISDS. But at this regard, what could we say about Mexico? Because if we look at data, Mexico is one of the most frequent respondent states in the world, being sued 33 times by corporations. And most of cases, 24 cases, started in the context of NAFTA. So Mexico has had even more cases in total than Canada, but it did not withdraw from ISDS. So why Mexico is still accepting the ISDS while Canada refused this system? Probably Mexico, as we know, had less contractual power compared to Canada during the treaty negotiations. And apart from the Canada exit, there are many other important differences compared to NAFTA. For example, under the USMCA, the claimant and the respondent, before starting a dispute in a court, should seek to resolve the dispute through consultation and negotiation. And in any case, claimants must initiate a domestic litigation in the courts of the host state before submitting their claim to arbitration. then investors have far more limited grounds for making a claim because, for example, claims for indirect expropriation may not be submitted to the ISDS. And also transparency has raised because a lot of documents such as the awards and the decision of the tribunal must all be available to the public. Well, the ISDS provisions of USMCA, it is true, it represents a wider trend in the world in which states are approaching investor-state arbitration with greater caution and with greater attention. There is a global trend away from ISDS. Some countries, for example, European Union at first, but also Indonesia, India, Bolivia, Ecuador, Brazil, and South Africa have voiced a strong opposition to ISDS. And this opposition was done in several ways, by terminating investment agreements with the ISDS, by refusing to negotiate in international investment agreements or bilateral, multilateral treaties with the ISDS, or by choosing other form of dispute resolution, or by modifying it as they did with the Nafta, from Nafta to the USMCA. This opposition is because the ISDS is hardly criticized for many aspects, the lack of predictability, the lack of transparency, and the lack of appeal, and what is worse, the menace to the regulatory power of states. What is worth to notice, in my opinion, and this is the second and last part of my speech, is that notwithstanding the general escape from ISDS and the amendments done by the USMCA on ISDS, taking thus the distance from the Nafta rules, this tool of dispute resolution is now attracting new consideration, thanks to the COVID-19. Let me explain you the problem. As we all well know, COVID-19 has led governments around the world to make intervention to contain and manage the COVID-19 emergency. I'm referring to the quarantine, the lockdown, the closures of certain types of businesses that have not been considered as essential. Let's think to the bar, the restaurants, the swimming pools, and so on. Well, the ISDS could open such government actions to claims for millions in compensation from foreign investors who get losses in their profit thanks to this decision. The risk is real because in the past, in other crises, in other situations of crisis, such as the Argentine financial crisis or the Arab Spring, those situations, those crises have led to many ISDS cases. So currently, we have from one side law firms and legal experts which are advising corporations on potential ISDS claims. While on the other side, we have human rights experts, trade unions, NGOs, and also UN bodies which are calling governments for a moratorium or for a permanent restriction on all arbitration claim by private corporations against governments. The point is that if it is true that the new Nafta limits the power of the investors, we need then to keep in mind two main considerations. The first consideration is that the Nafta rules, so the old ISDS, will still apply in the future for some investors. And the reference is to that investors which are contracting with the government with respect to some specific activities, such as, for example, telecommunication or transportation. Just to make you an example of the risk, think to the loss of profits caused by the lockdown to transport enterprises. Those enterprises, if coming from another country, could start a case against the government under the ISDS and to ask for compensation. Well, the second consideration concerns all the other investors who are not parties to cover the government contracts, But the fact is that the Nafta ISDS can be still used until July 1st, 2023. As a matter of fact, the period for legacy claims and thus the period to use the ISDS expires only 3 years after the termination of Nafta. This means that the US investors who have invested in Mexico, or on the contrary, the Mexican investors who did investments in the US prior to the termination of Nafta, will be entitled to the protection of Nafta for 3 years following its termination. Will it result in a rush of legacy claims before the USMCA cutoff date of July 1st, 2023? We will see. But to conclude, I think that it will be very important to monitor the potential rise of ISDS cases due to the COVID-19 pandemic. But what is sure for the moment is that the Annex 13D of USMCA with the new rules on ISDS may provide a novel model for future international investment agreements for those countries that share concerns and doubt about the effects of the ISDS on regulatory autonomy and regulatory power. Thank you for your attention.
Thank you very much, Valentina, for your analysis of the ISDS clause and about, in particular, the differences with respect to the Nafta. Thank you very much. And now I give the floor to Fausta Guarriello. Fausta Guarriello from Pescara, Gabriele D'Annunzio University, a very, very international scholar, and I am very happy to give the floor to Fausta. Thank you very much.
Thank you, Adalberto. I'll try to be brief because of the time. In my speech, I would like to start from the weakness of the free trade agreements on the application of the social rights contained in the social clauses annexed to them. The new treaty, USMCA, that replaced Nafta, seems somehow to remedy the inconsistencies of the previous side agreement by indicating precisely what is the core of the fundamental labor right that must be observed by the 3 countries that have ratified it, making explicit reference to the 1998 ILO declaration and somehow to maybe fundamental conventions referred to therein, not just a mere list of rights that can be interpreted at will by each country. The need to have precise terms of reference, such as the reference to the ILO conventions and the case law applying them, should provide a safer and less questionable parameter for the respect of the human rights at work that the 3 countries are committed to observe. It was this condition that Janice Bellace recalled in her report to the 2018 Congress in Turin, when she concluded with the word, "It must be seriously questioned whether the American approach to labor clauses in free trade agreements provides a model for the realization of worker rights. Approaches that link the labor clauses to ILO conventions, defining the fundamental rights, and which create an international forum for the resolution of labor rights disputes are needed." This was the words of Bellace in his report in Turin Congress. I had marked some doubt about, as Manfred Weiss do, the problem of the failure of United States to ratify 6 of the 8 fundamental convention, while Canada has ratified all of them and Mexico 7 out of 8. And the difficulties in enforcing these rights, which in US legislation or practice do not appear to be in line with ILO international law, especially with regard to freedom of association and the right to collective bargaining enshrined in Convention 87 and 98. I also remarked, as before did Manfred Weiss, the ambiguity of the mention in the social clause of the minimum wage in a new free trade agreement. I remember that the outgoing president, USA president, was in this regard moved by an intent protectionist to make the American manufacturing sector benefit from the clause that commits the parties to apply a much higher minimum wage than the practiced in Mexico, such that jobs may move back to the US or Canada. It is be hoped that the Biden administration that is taking office in the next few days will give the agreement a different meaning by committing itself to support a process of effective compliance with the ILO conventions mentioned as a benchmark for the enforcement of fundamental rights also and above all at the domestic level. But I found very stimulating, in addition to the specific subject of the seminar, on the question that accompanies it, if the USMCA agreement represents the signal of the new trend aimed at giving consistency and effectiveness to the social clauses and to the respect of the guiding principle of the UN Protect, Respect, Remedy, overcoming the phase of the use of the language of a fundamental principle and right at work as a mere illusory progress, a cosmetic operation of embellishment of free trade without paying real attention to specific meaning attached to principle mentioned, placing a heavy burden of proof on complainants for serious violation of human rights at work, not providing effective remedies. The rise of a tendency to overcome purely voluntary behaviors by companies and largely discretionary by the states, evaluated as completely unable to advance the goals of sustainable development of the United Nations 2030, is witnessed by laws adopted in recent years in states such as California, UK, France, Netherlands, on firms' mandatory due diligence for the extraterritorial violation of human rights at work in subsidiaries and in global supply chains. The requirement of mandatory due diligence with respect to voluntarily developed practices relates to specific sectoral areas, for example, minerals from conflict zones, or single objectives such as the abolition of forced or child labor, or general objective relating to environment and human rights, such as the case of the French law. But even national laws often do not escape the vagueness of the reference to fundamental rights at work and the very notion of supervisory and risk. The first visible impact for example, of the French law of March 2017 on duty of vigilance of the parent or principal companies shows a consistent implementation process driven by firms, which interpreted the law by resorting to managerial tools used in different areas, social accountability, risk management, and so on. Then the risk of managerialization of human rights due diligence is denounced by scholars and activists of NGOs who have especially fought for the approval of the French law and for its interpretation in line with the jurisprudence of international bodies for the protection of human rights and the environment. Through the publication of instruction on the application of the law, the constant monitoring of vigilance plans, and the strategic use of legal action aimed at having the existence of human rights violation recognized and at ensuring appropriate sanctions, this organization represents the only counterbalance to the risk that due diligence practices will be transformed, as corporate social responsibility already is, into a fig leaf of the activities of multinational companies around the world. Last observation, in the EU 2020 presidency semester, the German government supported the need launched during its presidency of the G8 in 2015 and G20 in 2017 to adopt a mandatory instrument on human rights due diligence in line with the EU Directive 2014 on disclosure of non-financial information and with regulation concerning particularly risky sector. The European Parliament and among social actors, the European Trade Union Confederation have expressed their support, their strong support for the initiative. The need to include global supply chains, which have become the dominant organizational model in millennial production and organizational processes, in due diligence obligations, has been repeatedly emphasized in international documents such as ILO's Multinational Declaration revised in 2017 and the Declaration on the Role of Social Dialogue of 2019. The eruption of the pandemic on the world stage has only reinforced the need to respond with hard law, regulatory instruments to the deterioration of working conditions along global value chains, which have also been put at risk by trends towards the relocation of economic activities already offshored to developing countries, and the use of short supply chains in the presence of supply risks. The pandemic has accentuated pre-existing imbalances and inequalities. The dependence of the production of essential goods and services, connection, medicines, health tools, on company operating on a global scale is the proof of an unavoidable global economic connection. Finally, tendency to hardening soft law could enhance the transnational company agreements present in many multinational companies to become a way for implementing human rights due diligence processes with the involvement of trade unions and workers' representatives as qualified stakeholders on labor issues. French law, for example, neither provides for nor excludes this, But so far, unions have played a marginal role in the implementation of the law until now. The European Trade Union, by contrast, aim at the full involvement of trade unions and workers' representatives in the whole due diligence process, in line with the right to be informed, consulted, and involved according to the European law. The question of the stakeholders to be involved in a human rights due diligence implementation process is still a complex issue to be solved, an object of cooperation, but also of potential clash between unions and NGOs, especially with regard to risk assessment and reliable monitoring processes. All countries are grappling now with recovery plans to get out of the severe crisis caused by the pandemic. The EU has given strong signs of discontinuity with the recent past dominated by the doctrine of austerity, paying renewed attention to social, environment, employment, digital challenges, and putting in place a massive series of investment to support the common effort of recovery in the name of social and environment sustainability. We hope that the revival of the stronger Europe and a new harmony with the Biden administration could support real progress on the issue we are discussing, contributing to taking human rights at work seriously in view of the realization of the UN Sustainable Development Goals. Thank you.
Thank you very much. Thank you very much, Fausta, for your intervention. Well, we are at the conclusion of our webinar, and we ask to Tiziano Treu for let me say that Council of Economic and Labor of Labor Law at the Catholic University of Milan, and he is the former president of the International Society for Labor Law and Social Security Law. Thank you very much, Tiziano, for joining us. And
thank you for the organization of this nice meeting. Useful and also nice, because I have the occasion now to see friends, even though at a distance. We are now discussing these issues after 1 year of pandemic, and this period has forced us to rethink, revise many of our ideas, not only in the field of labor. So if we engage in this process of rethinking, the pandemic may be a positive shock. Of course, the revision of categories and policies has been going on in this period in the national legislation and labor regulations. Well, I think it is urgent to reconsider also the international social regulation, because the globalization is here to stay. Maybe it will be redefined, maybe with different borders, regionalized, as we have heard, but certainly the need to regulate the pressures of global trade with the view of human social rights is more than ever necessary. Going back a few years where we have been studying the social clauses, the progress has been rather slow. I take what I've heard this evening as a sort of evidence that maybe also in this field there is an acceleration of processes going on for some time. Very, very interesting, the experience of this new NAFTA. From the European perspective, I simply want to stress 2 or 3 points which may be important also as strong suggestions for the future European policy in this field. One is this idea that in this field of procedures and enforcement of social clauses, which is a weak point in international experience, here we have a real improvement as far as I can understand. Like Lance Compa said, not only soft law, but strict procedures, regulations like burden of proof, which are in practice very, very important, and arbitration. Arbitration with good composition of the panel, powers, adequate powers, is essential in our view, in my view, to give teeth to the procedure of enforcement. And here we have a very good example. Of course, for Europe, this is particularly important. I mean, particularly continental Europe, where arbitration is not particularly used. In fact, if I well recall, when the TIPP, the international transatlantic agreement was being discussed, the European Union was proposing not really to rely on arbitration, but to some kind of specialized tribunals. Anyhow, this is one aspect that we must consider if we want to give more effectiveness, more practice in the law of international trade, social international trade. A second aspect, which has to do with the same aspect, the sanctions. The possibility to enforce sanctions directly on the firms is an absolute novelty. Again, I think we should take good note of this, because at the end, the states are intermediaries. They are the partners of the agreements, but the real strong points are what is the behavior of the firms, how this will be influenced by the social regulations. If I may, a third very important new attitude, new proposal is this idea of the value, labor value content, which, as Adalberto said, may be a sort of indication that some kind of minimum wage may be the horizon of these regulations of international trade. This is a vague idea in my view, but we should work on that. Going to some weak points are still there in the new NAFTA, apart from this vague, insufficient reference to the principles. Of course, you have pointed out the point, but I want to stress that the fact that the initiative to enforce these principles and agreements is exclusively on the governments. This is a real weak point. In the past experience that I know of these social clauses, if their enforcement depends on the initiative of governments, this is absolutely, in most cases, an obstacle to effectiveness. The involvement of the social and civil organization of the stakeholders has always been, in fact, a decisive factor even though this initiative is not recognized by the clauses, it has been in fact a decisive factor to enforce the principles and the conventions. And so I think this is a weak point which must be taken into account. I add another aspect of this, which was mentioned maybe by Manfred, the length of the procedures. If I understand well, some cases here are reported lasting 2 or 3 years. You know, this is a problem which we know very well in Europe, in Italy. Too lengthy procedures are the opposite of justice, as you know. So what can we draw? What can we see in the perspective? Well, Europe has to reconsider its policies in the future trade agreements. Not necessarily, certainly also in the transatlantic perspective. I have heard here some comments. Maybe that is not the easiest way. The prospect of having a good innovative agreement with the US, prospects are not very favorable, not even now that the administration has changed. But anyway, I think Europe should take the initiative to reopen this area of social regulations of trade, international trade. Of course, there is the other part of the world, the Asian area, the Asian countries, particularly after this enormous agreements which has been initiated by China and the rest. I think that Europe cannot avoid facing this challenge. And of course, that area will certainly present quite a few new grounds. But I think this is a challenge for Europe. Europe has recently showed great capacity of innovation in social policies. We were not, a year ago or 2 years ago, we were rather pessimistic about the future of social Europe. Now we've had, during this 2020, really a change of pace. And I think that this change of pace, this innovation in social policy should spur the European Union also to renovate their social policy in the international trade. We see. 2 more remarks because it's late. I think we should give more attention and ingenuity to increase the effectiveness of social rights, protection of social rights in the international supply chain. The issue has been discussed by the 2 colleagues of Venice. Here we are still basically with soft law. This due diligence process is in itself soft. It is voluntary so far, even though it might become mandatory, as I understand. There are some proposals, but this is an area in which, since the supply chain will become a critical area for the effectiveness of human and social rights, there we must make more improvements. Second, international collective agreements. Here too, developments, improvements are rather slow. This historic institution of industrial relations, collective agreements, has been weakened by crisis, by politics, and has not been able so far to overcome the limits of nationality. The effectiveness of collective agreements transnational beyond the national borders is still too limited. This is a whole area to where to invest. Finally, the courts, the possibility of national judges to help the enforcement of social rights beyond the borders is as an obstacle in the principle of territoriality of law. And that is again an issue which must be reconsidered. This is a part of the idea of law which has been built and shaped after a world of the past in which the nation was the center of decisions, and this is less and less so. So this has been for me a very interesting discussion, full of general and specific remarks. We think that there's a ground for new ideas and more specific field of analysis. Thank you, Adalberto, and to all of you. It was nice seeing you.
Thank you very much, Tiziano. And well, let's finish here. I thank you very much, Tiziano. I thank all our speakers again for their presence. And I also thank all the colleagues from the labor law community, in particular, Cristina Alessi and Vincenzo Pietro Giovanni, who made this webinar possible. Thank you very much. And of course, see you next time. Bye-bye.
Saluti, bye-bye.
Saluti.
Peruzzi as well. Grazie, Marco.
Ciao, Marzia.
Marco, of course, Marco Peruzzi. Thank you very much, Marco.
Sì, Marco.
See you, everybody. Soon, we soon.